It is Christmas Eve, December 24th, 2025, and this is the Court Gallery. Ladies and gentlemen, welcome to the Court Gallery. Tonight, I've got an incredible compilation spanning the full emotional spectrum. First, we got Judge Simpson, who meets a father and son nightmare where dad is forced to take the stand in a home invasion case, which is a preliminary examination against his own son. The most shocking part about this whole thing, his Ring video camera got the whole thing on tape, and we get to see some of it here tonight, ladies and gentlemen. From there, we're going to see Judge Hesselink, and he's going to be issuing some fiery ultimatums to a deadbeat dad with nothing but excuses and a struggling mom fighting for her children. It's family court, ladies and gentlemen. Names have been redacted, and wake-up calls will be issued. But from emotional to outrageous, we'll meet a Walmart man who was found trespassing not inside the Walmart, no, but on the roof of the store, ladies and gentlemen. And things like this can only happen on planet Washington. Staying in Thurston County, we'll hear about another neighborhood dispute like we've heard many times before. And all of that starts right now.
We're good. All right. Again, on the case of the people of the state of Michigan versus Zachary Duran.
Good afternoon again, Your Honor. Raymond Cook for the people.
All right, and we are ready to proceed.
People are ready, Your Honor.
Alex Warren, on behalf of Mr. Duran, Your Honor, the defense is ready to proceed at this time.
All right, very good. Do you make all your first one?
Thank you, Your Honor. People would call John Duran, and just for the record, I had a brief conversation with defense counsel. It's my understanding he's willing to stipulate to some People's Exhibit 2 that people will intend to admit. So I move to admit that now and certainly will provide testimony for that later on.
And Your Honor, for exam purposes, we would stipulate to what the people have pre-marked People's 2. These are text messages. Go ahead.
Okay. Exhibit 2.
Correct.
I will admit Exhibit 2, although it's been marked, and I'll admit that once it comes forward. Sir, please come forward to be sworn.
You take a seat, raise your right hand. You solemnly swear in front of the testimony about to give you the truth and all truth and nothing but the truth, so help you God. Have a seat. State and spell your first and last name for the record.
My name is John Duran Jr. Spelling on the last name is D-O-R-A-N.
And it's pronounced Doran.
Duran.
Okay, very good. You may inquire.
Thank you. Good afternoon, sir. How are you doing?
Okay.
Sir, where do you live?
I live at 13063 Saline Mountain Road, Mountain, Michigan, 3160.
Is that here in Washtenaw County?
It is.
Did you live at that address on September 6th of 2025? I want to draw your attention to that date. Did anything happen that day that led you to call 911?
Yes, it did.
What happened that caused you to call 911 that day?
Well, I was at work and I have an alarm system, or I have a camera system on my home, and I was receiving alerts. So I checked my cameras and I noticed that I had someone entering my home.
I want to pause you really quickly. You said you have a camera system. What sort of camera system do you have?
It's a Blink wireless.
Can you describe to the court what that is?
It's
No, go
basically a camera system that has indoor outdoor cameras that have a box that has, ability to communicate with the cameras as well as my phone to alert me to any presence of motion.
Who has access, or I'll phrase it this way, do those cameras record or do they just live stream?
Both.
Who has access to the recordings of those cameras?
I do.
Does anyone else have access?
No.
I believe you said that you would watch the cameras, you got a notification. What happened, or what was that notification?
Notification, there was movement in my entrance.
Were you able to see what caused that movement?
Yes.
What caused the movement?
I noticed when I looked at it, it appeared my son was in the house and he was coming through the door and then going into my home.
You said you saw your son. Do you see your son in the courtroom today?
He is,
Can you please point to him and identify him by an article of clothing that he's wearing?
yes, he's wearing a blue and white striped button-down collar shirt.
The record may reflect this witness has identified the defendant.
No objection, Your Honor.
Record shows so reflect.
Thank you. How did your son enter the house?
At this point, I'm not clear. He has had keys to my home. At one time, he lived with me and he's had access to my property. He still has belongings in my home that are there that he's either refused to remove or has neglected to remove.
Does anyone else commonly come into your house? Do you live with anyone else?
I don't live with anyone. I have my dogs in my home and my girlfriend will attend to my dogs on occasion when no one else is ever present.
Did you give your son permission to get into your house on September 6th?
No, I did not.
What did you see your son do at your house that day?
Well, what I can see from what was on the cameras was he entered the home and he was going through the end of my house where I have my waiting room, I have a spare bedroom. And he was going into the house to hook up a cable or a chain to a box that I had there.
When you left your house last, was the house locked, unlocked?
It's always locked. I worked in a prison way too long to leave my doors unlocked.
What was going on with the chain and the lockbox?
The lockbox was something that I had just property, and they were firearms, and they were I had them because he was having problems and issues, and I secured them in my home to keep him from them. And I told him he would get them back when we had a conversation about that.
What about the lockbox itself? Who owned that lockbox?
I did.
How much was that lockbox worth? Do you know?
Well, I bought it from an auction at Washington Community College. It came from their police academy. And I paid to have new locks installed on their high security locks that either have to be a special locksmith to obtain. I paid for the locks for it, and I was going to secure my ammo and my stuff in it. But because I needed space for his things, that's what I used it for.
How much did it cost to get that new lock system on it?
Locks were about $135, and then the box itself was like $10 or $25. Like I said, it was an auction, it was cheap.
Okay.
But the retail value was probably $450, $500.
Okay. Was there any property of yours inside the lockbox at the time that you saw the defendant taking the lockbox?
There was none.
Where was the lockbox located in the house?
It was just at the back of the entrance where he gained access to the home, and it was on the ground. It's a horizontal box. It doesn't stand upright, it's not vertical. So it was in the very far corner of that entranceway.
And when you say a box, how big of a box are we talking here?
6 foot tall, 3.5 foot wide, almost 3 feet deep. Very heavy. It's made out of, it's a box that they use at the police academy at Washington Community College to store ammo and firearms and stuff in.
Was the defendant successful in removing that box from your home?
Yes, he was.
And was that did that happen that same day that he was able to successfully remove it from the home, or was it a different day that he removed it from the home?
That was the day that in question. That was when I actually called and spoke to him on the phone while it was going on in real time as well as recording. What are you doing in there? Get out of my house. You don't belong there. Leave now. And he refused. He was he was on a rant, and I asked him numerous times and he refused, and I called 911.
Aside from taking this lockbox, what else did the defendant do in your home?
Well, when I got there after I got out of work, I seen that my gym was basically, I have a home gym, and it was just in a disarray. The biggest problem that was there was I had mirrors all the way around it, and over half of the mirrors were smashed into pieces. There was stuff was flipped all over into the middle of the room. I was missing a motorcycle and parts that was in the spare bedroom there. It was a project bike that I had.
I want to make sure I heard you. Did you say a motorcycle and parts or motorcycle parts?
It was a motorcycle that was in pieces. It was in a state of going back together to repair.
Gotcha. You said that you saw broken mirrors and some other damage. Were you able to observe what caused that damage?
As far as the mirrors go, no, I didn't see exactly because it was around the corner from the view of the camera, just slightly out of the line of the camera. The one thing that I did see that was damaged was one of the cameras, or a couple of the cameras themselves. I pushed a button to sound the alarm system on one of the cameras. He looked up at it and he shouted some sort of obscenities or whatnot, threw something at it, pulled the sync modules from the blink system, threw them across the room, and then my system went completely out.
How much were those cameras? How much did they cost to install?
I really don't know. I bought some of that stuff on Marketplace. I might have paid $50, $75 for a couple sets. Some people get tired of them, and I've integrated into my system. So that's.
What was the total, or I'll phrase it this way. Can you provide the court with a list of what all was damaged in the house?
I could, I don't have it this time. I mean, if somebody wanted me to go sit down and I see I had 3 mirrors that were this, these 2 cameras was that, the sync module was this, and the motorcycle, again, and all those things would be, I guess, subjective, you know.
Did you incur any expenses as a result of this incident?
I did some, yeah. I had to replace the front door. It was a old wooden door anyways that had a big glass window in it, so I wound up getting a steel door that had a small window in it to prevent such a occurrence again. So I put
Excuse me one moment. Excuse me one moment.
Sorry.
Oh, my apologies.
I believe I asked you if you could provide the court with a list or what all was damaged, and you were answering that question. If you want to continue your answer.
Yeah, like I said, if I went through and listed the things off, just off the top of my head, I don't know, maybe around $1,000.
Of things that were destroyed.
Yeah, I mean, like I said, I got two mirrors. If I had to pay retail value for those mirrors, I wouldn't even begin to tell you what would have to replace those, but I bought them used off the marketplace and got huge mirrors, paid not nice to nothing for them, and it took my time and labor and effort to install them. They were of more value than what I had into them.
What is the retail value of those mirrors?
The retail value?
Yeah.
I don't know if I paid a glass company to come and install those mirrors in my home, it probably cost me $1,500, just the mirrors.
Okay. Now you said that you were watching all of this via your home camera system. Is that correct?
Mm-hmm.
Does that camera system record?
That one does. I have 2 systems. I have a Ring camera and I have a Blink. The Blink is the one that I have a subscription for that records. My Ring camera was one of the ones that was it was picked up and pulled off. It was actually pulled off the wall and thrown at the other one, and that's when the sync module got unplugged and the system went down.
Can that system record while you watch it, or is that something separate?
It can if you have it set the settings for it, because I had to put those new cameras on the system without changing some of the settings. Once it went to a live view, it didn't record those. I subsequently anytime I have a live view, it does show. Because there was times they would get to the minute that the cameras were set to, it would go to a live view, but it stopped recording, and I'm on the phone, get out of my house, telling them to get out of there.
Did you watch any of the recordings from that day?
Briefly, some of them, the only reason I looked at it was to send them to the MSP trooper that came to the house to investigate the stuff.
If you were to see some of that footage, would you be able to recognize it?
Of course.
I'd like to put up for identity or authentication purposes what's been marked as people's proposed exhibit 1.
Yeah, just switch it over for me.
And I have it paused just at the beginning here. Sir, do you recognize what this video is or what this frame is?
Yeah, that's the entryway out the one end of my home. Like I said, if you look to the right in that picture, you see a heavy boxing bag, you see my dumbbells, and as you come towards where you see him bent over standing, that's where that horizontal box is just past the file cabinets.
And this recording, is it a fair and accurate recording of what you observed as to what happened that day?
Yeah.
Your Honor, I move to admit what's marked as People's Proposed Exhibit 1 into evidence.
No objection, Your Honor.
Exhibit 1 is admitted.
Permission to publish?
Yes.
And we are starting from the beginning. Just for the record, this is about a 5-second long video. Really quickly, just replay, just that way it's back up, so that way we can pause it. So I want you to pay attention or look down. There's an individual in the middle there, sort of at the bottom middle. Who is that individual?
That is my son.
And can you see, it looks like there's something between his legs on the ground there. Do you see what I'm indicating?
Yeah.
What is that?
Appears to be a chain of some sort that he's hooked to the back of his vehicle and went through the doorway and hooked it to that box.
And did you see what the defendant was able to do with that chain? Is that what you were referring to earlier with the lockbox and the chain?
Yeah.
Okay.
Well, it's fairly heavy, anything that one person could move around by themselves very well. So, and with some assistance necessary, so that's what that's about.
We can take me off, please. Thank you. And you said that you had been talking with your son on the phone while this was happening. Do you have any other communication with your son about this incident?
Do I have any, are you talking about what timeline afterwards, or?
At any time, did you ever just talk with him about this incident?
I told him you crossed the line with that one, and there's consequences for this. You know, I would never went into your home. You had no business being in my home at this time, because I told you to stay away because of the situation between us.
Did you ever exchange any text messages with the defendant?
Yeah.
And if I may approach the witness with what's been marked and enter as People's Exhibit 2.
Yes.
Let me bring you what's marked as People's Exhibit 2, and I have a copy for the court as well, if the court would like.
Thank you.
Sir, do you know what these are?
Yeah, they're screenshots of text messages.
Who are these text messages between? Do you know?
Me and my son.
And the text messages that are outlined in the gray, who's those
Those
texts?
are the ones that Zach sent.
And so the ones in green, are those yours?
They are.
Do you know when these text messages were sent?
It says at 12:29 and 12:48, the time, I believe it's the same day that, it kind of cuts off, so I can't see the date. I assume these are from the date that this stuff, went down in September.
And specifically drawing your attention to page 1 there, where it says, "I'll see you soon, I'm coming to get all my things." What did that mean to you?
What it says to me is that I'm coming to get my things. I don't know exactly what he was speaking of. I really didn't understand what he was talking about at that point, but he has multiple things in my house. And at that time, like I explained, that box had firearms in it that I retrieved from him earlier in the year because of a incident that occurred. I took all of them out of his home and I secured them, and I told him that I would keep them for safety and that they would be secure at that point.
Do you remember what time of day the defendant entered your home?
I do not specifically know. I know I was at work.
What time do you work?
Work from 9 a.m. till roughly 5:30 p.m.
Do you remember if this happened before or after your lunch break?
It was before.
And when did you take your lunch break?
Whatever more or less whenever I
Gotcha.
feel like it.
Okay.
I got a little bit of leeway in that.
At a couple points throughout the text messages here, it looks like the defendant is referring to a box. Do you know what box that is?
Box is the one that we described, and you see the picture of there that the chain was hooked to, was a lock box that I had.
So that's the same lockbox that was taken.
Correct.
Did you give the defendant permission to take that lockbox?
No.
Did you still live at this house at the time that this offense occurred?
Yes, I do. Yes, I do.
One moment, please, Your Honor.
Yes.
Ask the witness.
Cross examination.
Thank you, Your Honor.
Afternoon, Mr. Doran. My name's Alex Warren Green. I represent your son in this case. Mr. Doran, I want to confirm or clarify a couple of things from your direct examination. You have in your possession today the motorcycle and those safes or lock boxes, right?
They were returned afterwards before he was arrested and brought in for these charges, and he returned them to me, and only part of the bike was returned. So some of the things that were returned, some of them are still gone.
Okay, so, and I appreciate that. Mr. Doran, on this date, the date of this incident, when the police arrived, you were wearing like a uniform, right?
Yeah,
And at this time, September 6th, 2025, were you retired from the Department of Corrections?
I am actively a security officer, armed security officer with Lewis Jewelers in Ann Arbor, 300 South Maple. And I was in uniform, correct, and I was carrying a firearm at that time.
You were wearing the uniform associated with your private security job, is that correct?
Yes, I was.
Thank you. So on the date of this incident, you were under the belief that my client entered your home using a key he had. Is that your recollection?
I don't know how he entered the house, and I told him he had a key.
Okay. And you remember telling the police you think he may have used that key to enter the home
I did.
because you had given him a key?
He had a key from years ago. I couldn't force him to give it back. Otherwise, I would have retrieved the key before. It would have been a physical altercation for me to obtain my key back.
And he had previously lived at this address. He was still receiving mail or still does receive mail at that address?
He receives one piece of mail that I've requested on numerous occasions for him to redirect, and I went through the post office after this incident to make them have a hold on it so I don't get it anymore.
So after this incident, you asked for the redirect. On the date of this incident, he was receiving mail at that home. Is that correct?
Yes.
Okay. And there was a bedroom maintained for him at that home, correct?
Pardon me?
There was a bedroom for him at that home?
No.
Fair to say he's come in and out of that residence on a number of occasions throughout the years, right?
Right.
Okay. And at this time, you had his guns in your possession at that home, right?
I did.
When did you get those?
They were back in January when he was given a 72-hour hold. And he actually asked me to retrieve his home because he was afraid of the individuals he was hanging out with was going to ransack his home and steal them.
During the time he was on a 72-hour hold, a psychiatric hold, and you took those guns from his residence, is that correct?
I did.
And you say you had permission,
I did.
and you told the police this, right?
I did.
And you didn't show the police that you had permission to have those guns, did you?
They didn't ask me to show them permission. They told me that was fine because they had dealt with him. The police in Milan know me because of constant contact with them because of my past career as a corrections officer.
So, okay, going to September 6th, when you were observing this, you were not at home and you weren't at home at any time that Zachary was at the residence, were you?
Correct.
And you called and you spoke to a state trooper prior to arriving there, right?
I did.
And they arrived before you arrived. Is that your recollection?
A little bit before I did, yes.
Okay. When you got there, you were the first person to go inside the home.
I believe so.
Okay. You remember going inside the home by yourself before any officers went inside of
They
the
went
home?
in with me. Right behind me.
So you don't recall, or you're saying that you did not go inside of the residence before any officers entered the residence?
When I went to the door, they told me, please be careful, there's blood on the door. I said, okay, I see that. I'm not concerned about that at this point. I said, I'm going to go in, and they followed me, and we all walked in together, myself as well as the officers that was on the scene.
As a person who's worked in law enforcement before, you're familiar with the concept of kind of securing a scene, right?
Correct.
And doing a protective sweep of a scene, right?
Mhm.
And you remember when the police asked you if they could do that, refusing to allow them to go inside before you to do a sweep?
I didn't refuse anything, sir. All I did when I walked in the house is tell them I had 2 dogs in there, and one of them happens to be an American Pit Bull Terrier, and I, being a one, connected to law enforcement, 2, understanding the possible feelings about seeing a dog like that, I wanted to assure him that he was, 1, friendly, and 2, that I would go in with him. That was the only reason that I never refused anything. They never told me to stay out.
So if the police officer were to say something to the contrary, they are not telling the truth. Is that correct?
I would believe that that's the case. I don't remember anybody telling me to stay out of the house.
Mr. Doran, on your direct examination, we watched video from your home surveillance system. You'd agree that nowhere in that video you can see my client breaking or destroying any of the property inside of the residence, right?
The video camera in its position does not allow that, correct?
And you testified about some broken mirrors. Were there 2 or more of those broken mirrors?
There was.
I'm sorry, I'll clarify my question. Were there 2 of them or were there more than 2?
There was 3 in total. I had
3 in
4
total.
mirrors and I just put up. 3 of the 4 were broken. There are all kinds of still pictures of those mirrors available as well.
You provided those to the police?
I sure did, and they took them while they were there as well.
You didn't provide the police any photos or video clips of the condition of that property prior to September 6th, did you?
No, I was not asked for it. After I updated my home gym, I'm proud of what I've obtained as far as my weights, and I got all of this stuff. So after I straightened it up, I always take pictures of my workout area, post it to social media. So yeah, there are pictures of it in its prior state.
And with respect to this motorcycle, you're aware that my client, he does mechanical work, right?
Yeah,
And the motorcycle was broken down into a disassembled state, right?
it was.
You testified that the motorcycle was broken down, it was disassembled on this date, right?
It is a project bike, correct?
And that bike is not seen in the video we watch on direct examination, is it?
The bike was not in any pictures. It was in the room, and like I said, when the picture would go to live view, it stopped recording. So in the interim of that, where he was going into that room, that's when the bike become missing.
People's Exhibit 2 was a series of text messages that you provided to the police as screenshots, right? You still have those in front of you?
I do.
Okay. And Your Honor, if I could have a moment to confer with the prosecutor.
Yeah, go on. It's right.
Okay. And that's how it appears for him?
Yes.
Okay. So, Mr. Dorn, generally speaking about those text messages, the gray is text messages received from Zachary, the green is text messages sent by you, right?
Yes.
And the green ones are cut off in almost all occasions that a green message appears. It's cut off, right?
I'm not sure why that is. Because of the way they were copied from the text messages as they were received, that's not intentional.
And you never provided, no one ever asked you to provide your phone for forensic extraction purposes, right?
No.
So you took these photos as still frame screenshots on your phone and just gave them to the police, right?
I did.
So when a text message is cut off, that would be because of the way that you framed the picture. Is that fair to say?
If there was anything cut off, normally what I do is take another screenshot to show the rest of the pictures, so I don't know where the other part of that is in reference to these copies that I have here. I don't know if they're available somewhere else or whatnot. I generally would make sure that you have the entire message to make myself clear.
And you're testifying that you did do that in this case, you provided the entire message to ensure that it's clear.
I can't tell you 100%, but I'm pretty sure that's how I sent them or done them. That's how I do it all the time.
And the prosecutor marked these, the ones you have in front of you, as people's 2, and then I believe there are small numbers 1, 2, 3 at the bottom. Is that how they appear to you?
Yes.
So if you could go to page 3, which is people's 2, small 3. You see the part where Zachary says, just put the key in the mailbox?
Yes.
These text messages were sent before Zachary entered the home. Is that correct?
As not having the date there in reference, I can't tell you that. All I see is the time. If it had the date, the date of the incident, I can tell you that.
And to be clear, the time is the time in the top left of each of these still frame photographs. That is the time displayed on your phone, not necessarily the time these texts were sent or received. Is that correct? Correct?
Yeah.
Okay. The only time a date appears is on people's 2, 3, which is Wednesday, September 10th at 7:43 p.m.
Could you repeat that question, please?
I'm sorry. On the 3rd page of People's Exhibit 2, the 2nd picture on the bottom, there is a date and timestamp on that, right?
Yes.
Okay, but other than that, there are no dates and timestamps.
Correct.
And
To my knowledge, like I said, I still have the phone and I haven't deleted any of the stuff. You can take my phone right now and do whatever forensics you want to at that time, no time.
Your Honor, I have nothing further at this time.
Any additional questions?
Yes, Your Honor. Sir, just to clarify, was any of the property that you told the court had been damaged in this incident, was any of that damaged prior to the defendant coming into your house?
No.
Nothing further, thank you.
All right, thank you. You may step down. Thank you, sir. Any additional witnesses for the people?
None from the people.
Any witnesses for the defense?
None from the defense, Your Honor.
Do I have a motion?
Yes, Your Honor. People move to bind over as charged in count 3 tagging along.
Response.
Object to bind over, Your Honor. With respect to count 1, the home invasion, 2nd degree, that charge in this case is predicated upon a larceny having occurred within the residence. Your Honor, I would ask the court to consider in making the bind over decision that there has to be some evidence from which the jury could infer that Mr. Doran, my client, Mr. Doran, intended to permanently deprive his father of the property in question.
When you say permanently deprived, but that doesn't have a time on it. I mean, if he's going to deprive him of property at any point in time, that can constitute the larceny.
I understand that the court could reach that conclusion. I would ask.
Well,
the
but
court
that's
to
the law,
consider,
isn't it? Counsel?
Your Honor, I would ask the court to consider that the evidence, the testimony taken today established that Mr. Doran took things that belonged to him that were contained within a safe, which was returned to the owner. That's what I would ask the court to consider in this bind over decision. I would also ask the court to consider, with respect to the home invasion 2nd, that the people's evidence that Mr. Doran did not have permission to enter that home, I think significant questions are raised when the evidence establishes that Mr. Doran has a key to the home and that there are text messages asking his father to leave a key outside, presumably before this occurred. So I would ask the court to make the inference that if Mr. Doran had a key in his possession that was given to him, that he believed that a reasonable person could believe he had permission to enter that home. What those text messages don't establish is that he
You're
didn't.
gonna say that I'm to infer from all of this that he had permission to enter that home, hook up a chain to his truck to something in that home and drag it out of that home, and that somehow he had permission to do that?
Your Honor, I think those text messages are discussing, and what the witness testified is that there are items in that home that belong to my client that he has not retrieved, that his father testified he wants him to retrieve. And that's our position on what was going on in that video and what happened today, or at the date of the incident.
Okay. Oh, I don't really need much, but
Your Honor, I think even if, as it relates to the lockbox, even if the court didn't find a permanent intent right there, there was still testimony about the bicycle, which to my knowledge was not returned. So there's certainly a permanent intent to deprive there. I would again ask the court to bind over.
And Your Honor, may I very briefly reply?
yes.
Just to touch on count two. Count two is malicious destruction of personal property between 1,000 and 20,000. We did hear testimony regarding surveillance cameras and mirrors inside the home. I don't believe we heard any testimony with respect to a 2003 Saturn, as reflected in the people's information. So I would just ask that that not be considered in the bind over decision.
Right. Well, I've listened to the testimony of Mr. Dorn, and what is clear with reference to count one as to whether or not the defendant had permission to enter the home, the witness clearly has testified that he did not have permission, nor did the circumstances under which the court views the defendant in the home could lead the court to the conclusion that somehow he was there with the permission of the homeowner, his father. Further, it would seem to me that if indeed he had permission, or if I'm somehow to infer the request to leave a key as somehow, or that him having lived there, as many kids may have at some point lived in their parents' home, as constituting a constant permission. Had he had permission, it would seem to me that he could have said, "Can I get into the house and remove these items in some way?" But that's not what occurred here. And I don't think that I could make a reasonable inference that that's what he was doing. He was forcibly trying to take items, and some of those items belong to his father, namely the lockbox. When he's in the premises, and I can take Mr. Doran's estimate of the value of the property that is destroyed, he has indicated that with the mirrors, it's going to be around $1,500, but he said in excess, it's going to be over $1,000, and that was the property that was destroyed. So I would specifically find that people have shown that he entered that the defendant did enter the premises, and that while present in there, did commit a larceny in terms of removing the box that contained the weapons and ammunition. That in and of itself would be sufficient to constitute the larceny. And I, to the extent that the defense is arguing that there's a length of time, the larceny is actually complete upon the point at which he takes possession of it without the owner's permission. So the people have shown that. With regard to the malicious destruction of personal property, clearly the testimony of Mr. Duran was that there were his sink units, the cameras, the mirrors, motorcycle parts, and other things that were destroyed or otherwise injured, and that the total amount is in excess of $1,000. So the court would find that the people indeed on count two have sustained their burden. So for those reasons, I would find that the If the people have sustained a verdict, would bind the defendant over to stand trial on counts 1 and 2, with count 3, the malicious destruction of the building following.
Your Honor, we acknowledge receipt of the information in this case, waive its reading and stand mute.
Defendant having waived formal reading, standing mute to all 3 counts, court will enter a not guilty plea. Pretrial in this matter will be
February 12th at 1:30 before Judge Slay.
February 12th, 2026, 1:30 before Judge Slay. Are there any issues with bond?
None from the people.
Bond will continue. Thank you, folks.
J-25-335-NA and also J-24-273-NA. If I could have the attorneys place their appearances on the record, starting with Mr. Sommerfeld.
Thank you, Judge. Don Sommerfeld for the Department of Health and Human Services in the Ireland children matter.
Larry Brown on behalf of respondent mother Kendall, Ireland.
Donna Hansel,
Go ahead, please.
Donna Hansel on behalf of the minor children. I would say, Your Honor, I'm sitting outside in Texas. I can go inside. I thought it'd be quieter out here, but I do hear some traffic. So if you need me to go inside, I will do that. Sorry.
I can hear you just fine right now. So until we hear the big trucks really laying on it, we'll let you stay outside where it's probably a little cooler and nicer.
Nicer. Yeah.
Go ahead, Mr. Delaney.
Well, now I have to ask Miss Hansel a question. Which minors do you have?
I have, okay, let me read them to you. I have,
Okay.
I think you're Cody, Mr. Delaney.
Correct. I was looking at my docket for 1:30 for the quick matter, which was also heard this morning, but I'm counsel for Cody, Ireland on this one. So thank you.
okay.
Yep. All right. And I do see Ms. Hughes from Wellspring. I do see Cody, dad, and Kendall, mom, are with us as well. All right. Today is set for a review hearing. I have the following reports. The court report dated 12/23/25 from Wellspring. Parent agency treatment plan for the period of July 28th through October 25th of 25. Case service plan from that same time period. A second parent agency treatment plan involving children, it looks like, and then MDHHS updated prevention plan. Forensic fluids laboratory reports, and the foster care supportive visitation and in-home parent education weekly progress report for the period covering December 4th to December 10th. And then finally, an email from Molly Mason to Lori O'Neill regarding parenting time of Cody. Any other documentation I should be aware of, Mr. Sommerfeld?
No, that's all I have, Judge.
Any objection anyone has to the court considering those documents?
No objection.
Objection.
All right, those will be admitted. Mr. Sommerfeld, do you have a witness for me?
Yes, I'd like to call Kelly Hughes from Wellspring.
Ms. Hughes, would you raise your right hand so I can swear you in? You swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, thank you. Mr. Sommerfeld, go ahead.
Thank you. Miss Hughes, can you state your name, please, and spell your last name?
Kelly Hughes, Hughes.
And how are you employed?
I am a foster care case manager with Wellspring Lutheran Services.
And are you familiar with Ireland?
Yes, I am familiar with their case, so I am not the case holder. I'm standing in for Miss O'Neill today.
All right. So you have knowledge of the documents that were identified and admitted into evidence today?
Yes, I do.
All right. I'd like to talk first about Mr. Ireland. This is Cody Ireland. When I look at his agency treatment plan under substance abuse, it says that it's rated as poor. Are you familiar with that?
I am not and was not provided that report. I was only provided the court report for today's hearing.
Okay. Well, can you tell us, is Mr. Ireland, is he participating in any services related to reunification with?
So based on what I reviewed on the report that was provided to me, that Mr. Ireland is, he did complete a substance use assessment. It did not appear based on the report that he has completed the second recommended substance use assessment. He has not engaged in any AA or NA meetings. He has not engaged in the prime course that was recommended on his first substance use assessment. He has engaged in, I believe it was 3 substance screens, which were all negative for any substances. He reports that he has cut way back on his substances to the point where he was drinking like 1 beer a day approximately. Though it was reported by Miss Ireland to Lori that that is not necessarily the case. He is participating in foster care supported visitation, and based on their reports, it did state that he is making some progress. He is showing benefit from the programs that the foster care supported visitation programming.
Okay, is substance abuse for Mr. Ireland, is that a critical need domain for the purposes of reunification with his children?
Yes, it is.
And why is that?
Because his substance use was part of the concerns that brought the children into care, and there has not been much progress regarding the substance use.
Okay, and what substance was at issue here for Mr. Ireland?
Alcohol.
So you're reporting that he has not abstained from alcohol and continues to consume?
That's correct.
Is he employed?
He is employed at doing a cash under the job construction per report.
All right. And how has he been interacting with his children during parenting time? What has been reported?
Reported on the report is that the parenting times with the foster care supportive visitations have been going well, that he's been showing progress in the programming, and his foster parents or his mom and dad who supervise the parenting times at his home also report that the supervised parenting times have been going well there as well.
Okay. Now, are you familiar to comment on Kendall Ireland?
Based on the report, yes.
Okay. And she is, so you also are not aware of what is in her parent agency treatment plan?
I am not aware of the parent agency treatment plan at this time.
Okay. I'd like you to comment on Miss Ireland's progress, because she seems to be in a different situation than Mr. Ireland.
Yes, that is correct. So Miss Ireland's children were returned home on or around October of 2025. She's been working with foster care supported foster care reunification or family reunification program, FRP, also known as. She has been engaged in that programming. Based on the report that I had this morning from the supervisor for that programming, it states that Kendall is very eager to have that programming come to a close. It looks like they're slated to close on the 8th of January. And that Kendall is progressing well, meeting the goals that were achieved in that in the initial referral for that programming, and that she's doing a lot of the work on her own and meeting the resources and requesting resources as needed for her family to best support them.
Okay, and Wellspring is asking the court potentially forecasting a case closure for Miss Ireland in the next 2 months if she continues on with this progress.
That is correct. I know that Ms. O'Neill did want me to make note that it would be the recommendation that we come back in 60 days versus 90 days for a potential case closure, and that it was the recommendation that she work with
FOC.
Yes, friend of the court, sorry, thank you, with friend of the court to file for a custody order for physical custody of all 3 children. It is also recommended that with that case closure that the supervised parenting times continue for Cody at that point.
Okay, and has Miss Ireland, is she taking further action? Is she about her marriage?
Yeah, so Miss Ireland, when I was the case holder, did provide me with a copy of the court order for that she had filed with the courts for a divorce from Mr. Ireland.
Also, the report indicates that she is in the process of engaging in the SMILE program, which is related to divorce matters in Michigan.
Yes, that is correct. She actually has that, I believe it's scheduled for the 6th of January.
Okay. Can you tell us, I mean, I'd like you to give some description here if you can. What is different about Miss Ireland? How has she progressed to a point from where this case started to where she is now?
So that I can contest to, because I was the case holder earlier on in the case. And Miss Ireland's home was pretty deplorable when the kids came into care. The home was, they were initially living at a trailer park here in Gaylord. The home was in pretty deplorable condition. It was not clean, it was not sanitary. Miss Ireland's emotional stability was very compromised at that point. She has worked very hard seeking safety, working with Catholic Human Services, working with Women's Resource Center, working with NEMSCA. She is engaged fully in her parent agency treatment plan and has made significant progress and continues to show benefits in the services that she engaged in and continues to engage in them. She has demonstrated her ability to recognize when she's struggling and to reach out appropriately to those supports to whether it's asking for additional therapy sessions or support from her community network that she has created for herself. She's definitely became more self-sufficient and not so codependent upon others.
Okay, and isn't one of the things that has kind of liberated her is that she's got a driver's license and has actually got a job as a delivery driver?
Yes, that would be correct.
And so that's one thing that is where she's not relying upon Cody Ireland for support in that area of transportation.
That is correct.
Okay. How does Miss Ireland, does she communicate well with the department? You talked about how she's doing well in her services, is trying to do more than she should. Is there an equivalency in her communication between your agency and Miss Ireland?
Yeah, so even with our agency, she maintains pretty adequate communication with the department. You know, she's always advocating for herself and just talking to the department. She keeps the open line of communication. She brings concerns to us as they occur. So like if something has happened and it's concerning to her, she'll bring them to Miss O'Neill and discuss those with Miss O'Neill or discuss those with her FRP programming as needed.
Okay. And Is there anything else you would like to offer today?
Not at this time.
All right, thank you. I have nothing further, Judge.
Thank you, Mr. Sommerfeld. I believe Ms. Ireland has her hand up. Is there something I can help you with, ma'am?
I just had a question for Ms. Hughes. It was kind of like going back to like how my household looks now compared to how it used to be.
I'll certainly give you an opportunity to state anything that you want once your attorney has a question for you. But let me ask you to hold that thought for just a minute, and then I'll let your attorney ask questions. And then you can make any statements that you'd like or ask any questions you like at the end. Is that all right?
Thank you, Your Honor.
All right. Mr. Delaney, questions?
I wanted to go over the recommendations again. The first recommendation with respect to substance abuse was completed or engaged in. Is that correct?
So the first recommendation for substance use was that Cody would do a initial substance screen, which he did. However, it came back as though Cody's substance use was minor. So we did request when I was still the case holder for Cody to engage in a second or a repeat substance assessment, which has not been completed to date.
It appears that Matt Lawrence was the initial worker on this, and then was it transferred to you, or because you're Wellspring, that would have been the ordinary path, DHS to Wellspring?
I personally have not worked with Matt Lawrence. It's been Ann Sullivan.
Okay. And I'm looking at the petition, the initial petition in this case, which went to a jury trial. Have you had an opportunity to go through that initial petition?
Maybe when it first opens, almost a year and a half ago.
Okay. And the reason I ask is that, would it be your recollection that several of the core allegations were that the children had encountered, let me just see here, some substances in the home? Do you recall that?
I do recall that there was issues with substances. I cannot recall whether it was in the home or outside of the home, but that there was an issue with substances.
Okay, specifically that the children had come in contact with this, with illegal substances, is where I was going with that.
Yes.
Okay. Either gummies or marijuana and trazodone. Is that your recollection?
Judge, I want to object here. We had a jury trial. The jury found what they did. That is what the facts are. And I don't know if Ms. Hughes has the personal knowledge here to answer the questions. I don't know where Mr. Delaney is going.
I'll let him know. The substance of her testimony was that alcohol was a premise, if not the premise, of the petition for Cody. And not that the court can't order that in any event, but I don't think that it was what led to the adjudication in this case. And so their suggestion is going to be, it was because of alcohol, he's not participating and he's not following through with the parent agency agreement. And as I indicated, the court can certainly make that a requirement. That can't be disputed, but I didn't want there to be that lever here that it was all about alcohol and now he's defying the court's order. That's my point.
Well, Mr. Delaney, I don't really care why he's defying the court's order, but there was a court order that said he'd get the assessment done a second time. It was a request from DHH or from Wellspring and DHHS, but it was an order from me. So quite frankly, I don't care why he didn't get it done. The only question is, did he get it done? So let's move on.
those are my questions then, and I can address these with Cody. Thank you.
All right. Mr. Brown, questions? You're on mute, Mr. Brown.
I apologize, Judge. Ms. Hughes, you mentioned that Kendall is pretty much doing everything she is supposed to do. Ms. O'Neill is contemplating an early review period to hopefully close this case. Is that correct?
That is correct.
Do you have any knowledge of why the review period is going to be within 60 days?
She had just told me that she would like Miss Ireland to be working with FOC and get that order in process, and she would like her to successfully complete the family reunification program, and then wanted to monitor the case for a short period of time once that program was out of the home to ensure that Kendall didn't need additional support.
Okay. And you are familiar as well that there are two cases, 3 children, but they're kind of bifurcated into 2 separate cases. There's another case that is actually scheduled for a trial coming up. You're aware of that?
Yes, I am aware of that.
What is the department's position? Because the case, which there was never a removal, it was in home. What is the department's position should that case be closed and there still be an open case with pending trial?
So I would not really be able to testify at this point on that particular case.
Okay.
I've not had any formal discussion with Miss O'Neill as to what her recommendations would be at that point.
Okay. Thank you. I have nothing further to add.
Ms. Hansel, do you have any questions for the witness?
Real quick, it would appear that there has been some illness in the home with the children, but that it has been appropriately addressed by the mother. Is that correct?
That is correct. That's what I read in the report as well.
Okay, so you have no concerns as to her ability or her actions when the children are in need of care, medical care. She has been willing and able to address that. Is that correct?
That is correct.
I have no other questions. Thank you.
I have no questions for the witness either. Mr. Sommerfeld, do you have any additional witnesses or evidence?
I do not, Judge. Thank you.
All right. Mr. Delaney, witnesses or evidence?
Cody, I anticipate you would like to testify in this case.
Yes.
All right, Mr. Ireland, if you'd raise your right hand so I can swear you in. Swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, Your Honor.
All right, put your hand down. Go ahead, Mr. Delaney.
All right, Cody, I'll cut to the chase. If you've been paying attention at all, you can anticipate the court is going to ask you about the alcohol screening and testing issues. So I'll save the court the question and just ask you directly. Can you elaborate on what's happening there? There was a screening, there was a request for a second screening, and it appeared you didn't participate in that. Or can you tell us what is happening there?
So my main concern is I've had 4 caseworkers in the last year. So I'm not getting any information because I've asked about if I needed to pay for it or if you guys would pay for it. So I'm in that conflict, like, what is going on? Yes, you did order it. Yes, they recommended or recommendation to go there. But I'm in the middle trying to figure out if I got to fork out money out of a loan from my parents.
Who was the first test with? And you kind of froze up for a second there. Who was the first test with?
It was an mid-aged lady. It was through Catholic Human Services.
And how much did that cost?
I have no clue.
I'm sorry, did you say you don't know?
And I don't know how much, I do not know.
All right, now how about the second test? Who's that gonna be with?
It would be same place, Catholic Human Services.
And do you think there's a cost issue that you can't meet?
I physically can't for all my stuff. I'm going to neurology. I have no insurance through anything. I've been trying to get my insurance, but they've been denying me insurance. They were supposed to talk to DHS about it. My caseworker, Sarah, she was supposed to get a hold of somebody at DHS to figure out what the situation was for my insurance. So I have all this stuff up in the air right now, trying to figure things out because it takes insurance, or I got to fork out thousands of dollars that I don't have.
What's your view about alcohol consumption in general? Because that question is going to be asked today, and I may as well be the one to ask it.
Alcohol consumption. Like, am I still consuming alcohol?
Yes.
That would
Are you
be
drinking?
yes.
That question will be asked of you today. There's no question in my mind.
Yes, I do consume alcohol, but not when I have a visit or when I go see for my thing at Wellspring, or even if I have a meeting with a caseworker, or even during the day. If I do anything, it's at night, and I only have like 1 or 2 beers at night.
Is that every night or on occasion?
It's honest. Sometimes I don't drink, sometimes I do drink. It's just depending on the day and if I'm too tired to drink or whatever the case may be. But I don't drink every day.
What else are you doing outside of the alcohol issue that I think we covered to comply with the case service plan?
I was supposed to go to Prime for Life, but they were trying to figure out the pricing and the payment for that, if I had to pay for it or if they did. And then the men's group, I don't know that's up in the air too. A lot of this stuff is up in the air.
All right. Anything else you want the court to be aware of regarding your progress?
Not at this time.
All right. Thank you.
Mr. Brown, questions for this witness?
No, Your Honor.
Ms. Hansel, questions for this witness?
Yes, real quick. Mr. Ireland, who did you contact since the last time we were in court? Who did you contact to find out about payment for this recommended second test that you needed? Who did you call?
That would be sir.
You broke up.
I have called them. So I haven't called them. I'm trying to figure out with Hill Springs that we're gonna do. The recommendations are.
Your Honor, Cody's currently working on a construction site right now. That's why his signal keeps dropping in and out.
Thank you. Hopefully we'll get him back.
I'm back.
All right, go ahead again, Ms. Hansel.
So you understood your answer correctly. You were waiting for Wellspring to contact you. Is that what you just said?
No, I was waiting for the how we were gonna pay for it.
Right.
They were supposed to get a hold of or get a hold of their higher ups to figure out if they were gonna pay for it, or I needed to pay for it.
Okay, and was it I'm sorry, it's a little loud where I'm at too, but is it the Wellspring agency that you were going through to find out who was going to pay for it?
Yes.
Okay, but you didn't call them? When you didn't hear from them, you
I
didn't?
have not called them.
Okay. And you recognize these are your children, correct?
Yes.
Okay. So how long ago was it you were recommended to get this second test?
I have no recollection of when it got put in. I haven't been getting told pretty much of anything on just what I need to do. And as I said, I've had 4 caseworkers in the last year. So there's different things that are going on in between all 4 of them. And so I'm just confused at this point on what I need to do compared to what really needs to be done to get my kids back.
Okay.
I understand the alcohol, but there's other things in there that I'm just like, okay, like I don't know how I'm going to pay for it, but also like.
But you're currently working, correct?
Yes.
How much are you making per hour?
$20 an hour underneath the table.
Okay. Are you saving some in case you need to pay for your own?
I just got back into work because I got laid off for a little bit due to neurology issues.
Okay. So prior to you getting laid off for a little bit, were you saving any of your money for this testing?
I was not.
Okay.
Because I was trying to provide for my family at the time to get them food, dinners, and everything for my visits at my parents.
Okay. So, all right. So just to clarify, did you contact your lawyer to find out, to express to him concern about not knowing who's going to pay for this testing and wanting to progress faster so you could get your visits with your kids or get them back?
So I just got a new phone. So my other phone got disabled. So I wasn't able to make phone calls or anything. I have tried to call him a couple times before my phone got disabled, and then I called him today, wanted to talk to him today. So he's got my new phone number now.
Okay, I have no other questions. Thank you, Your Honor.
Mr. Sommerfeld, questions for this witness?
Yes. Mr. Ireland, can you hear me okay? Can you hear me okay, Cody?
Yes, I can.
All right, thank you. In your parent agency treatment plan, it's reported that you've been banned from a lot of bars in Gaylord. Did you tell the worker that?
I'm only banned from one bar for sleeping. Yes, I had a couple drinks that night, but I guess I fell asleep and then I hit my head, or somebody hit my head off the table or whatever, and that knocked me out or whatever happened. I have no recollection of what happened that night after hitting my head.
What can you tell us what bar that was in Gaylord?
That is Timothy's Pub.
Okay. And when historically, when you've consumed alcohol, haven't you had seizures sometimes?
That's what we're trying to figure out with my neurologist right now.
Okay.
If it is seizures or if it's just alcohol induced seizures.
Okay.
But I'm in the process of figuring it out with him right now, but I have no insurance to get the test done.
I mean, as a general point, do you think that, in your opinion, that alcohol is related to having seizures?
Even hitting my head, I get dizzy, nauseous, to the point where it looks like tunnel vision almost. Just even the slightest little tap on the head. I get those dizzy spells and everything else. But they say I might be having seizures in my sleep, even though sometimes I don't drink alcohol anymore. Like there's always that possibility between, yes, I could be drinking and have a seizure, or I'm just having seizures in general.
Okay. Do you
Due
think
to all my head injuries.
Do you think it would be smart just to maybe on your own experiment and to stop drinking alcohol and see what happens, like completely?
And the last time I did that was when just born, and it put me in the hospital. So I only got 2 weeks out of that. Since I've slowed down drinking and everything, there is a possibility I can do it now.
All right. Do you think that the drinking interferes with your ability to parent your kids?
In all honesty, like there are functional drunks and everything else where they can do everything. I understand statistics and everything else aren't proven that way. But in my opinion, if I only have a couple beers, that's not gonna. They say you can have 0.08 and be able to drive. What says 2 beers or 3 beers is gonna disable me from taking care of my kids? Like there's a big aspect there. I can drive a vehicle, but I can't take care of my kids. Like I understand to a certain point, but only a couple beers every day ain't gonna make an issue or make somebody not be able to take care of their kids, is my opinion.
Okay. Did you understate what alcohol, how you use alcohol during your first substance abuse assessment?
No, I did not. I told the truth. I did everything that I was supposed to. I told her how much I was drinking before and what I am now. And then that's what her opinion was. Like I was per se, what's the word I'm trying to say? For example, if I was to drink 12 beers and drop down to 6 or 4 beers after a month or month and a half, that's a huge dramatic step. And when I did my substance abuse, that's what I said. I was drinking this much so-and-so to the point where I am now so-and-so. And that's where we were in agreement there.
Okay. Thank you, Cody. I have nothing further, Judge.
Mr. Ireland, I have a couple questions for you. Have you gone to AA classes or AAA meetings?
I have gone to one class. I have a login sheet. I would have to find it. But I was gonna go another time, but some stuff happened with my younger son, so I was trying to figure out that. And as I said, I just got back into work, so I'm trying to get back into that to get money to provide for my family again.
Okay, Mr. Ireland, I didn't ask you. Mr. Ireland, I didn't ask you why you haven't gone. I just asked you, have you gone? And the answer to that is once. Once?
Yep.
Have you done the Prime for Life class?
I have not, because as I was saying, I was trying to figure out the situation.
Again, the question wasn't why, it was just have you. So the answer to that is no.
That is correct.
Have you gone and done the second substance abuse assessment at Catholic Human Services?
No.
Have you done the anger management classes that we told you to?
No.
Are you working full-time?
Yes.
When did you start working full-time as opposed to part-time?
I've been full-time for almost a year.
Are you paying rent?
Not at this moment.
When was the last time you paid rent?
When I had a house.
How long ago was that?
That's when I got my kids taken away. So a year and a half ago.
Have you tried to find out the cost of the substance abuse assessment from Catholic Human Services?
No, I have not.
That's all the questions I have. Any additional witnesses, Mr. Delaney?
None, thank you.
Mr. Brown, witnesses or evidence?
No, Your Honor, I think Kendall wanted to mention something about the home, but I will bring that up in closing.
All right, thank you. Ms. Hansel, any witnesses or evidence?
No, sir.
All right. Closing statements, Mr. Sommerfeld?
Yes, thank you, Judge. With this report, it looks like Miss Ireland is doing very well. We have a glowing report in her parent agency treatment plan. Her emotional stability behavior need domain is rated substantial. She's made a lot of progress from the beginning of this case, as evidenced by the reports admitted and by Ms. Hughes' testimony. I'd ask the court to adopt that recommendation set in the earlier hearing. I think it's a good course, but Miss Ireland thus far has demonstrated that she can take care of her kids. And this may even affect, I know that there's another case and we're going to have a status conference on Ireland, but depending on her progress, I mean, if she substantially complies in this case, there may be no need to have her on the second case at all. However, Mr. Ireland is a different issue, and I think by his testimony today, the court has witnessed from his own testimony, that's Mr. Ireland's own testimony, that there are issues here that are barriers for him parenting and having custody of his kids at that time. So I'd ask the court to adopt the recommendations, further to have Mr. Ireland complete things that the court says you got to do these things, and maybe address Mr. Ireland about his rationalization in regards to his own consumption of alcohol. Thank you.
Mr. Delaney?
I'll be brief. I know what Cody testified to, but I also know what the court is going to order when it gets to that juncture in this case, so I will leave that to the court.
Mr. Brown?
The first thing I'll bring up is the home situation that Kendall wanted to bring up. I don't think that is an issue. It just kind of goes without saying, given the reports. It is obvious that her home situation has tremendously changed. Otherwise, it would be a different kind of a report, but she is doing extraordinarily well. I do understand the 60-day closure after Ms. Hughes went through that. I know that Kendall wants to have this done. but I also know how the courts work, and this is going to be something working through the FOC, getting all of the divorce papers in order, working through the FRP. So I would ask the court to adopt the recommendations here.
Thank you. Ms. Hansel?
Yes, Your Honor, I would be in support of the recommendation as well. I would commend Mrs. Ireland on her success as she has progressed through this. I was very pleased to see how well she addressed the which could have been a very serious illness with the children. She sought medical help immediately and addressed that very, very well. I am very concerned about Mr. Ireland. I believe his testimony reflects that he clearly sees himself as a victim of circumstances here. I'm very worried that he acknowledges that if he quits drinking, he would end up in the hospital. However, he doesn't recognize it as a big enough problem to abstain completely and still feels he can drink some and it doesn't affect him. I just feel that that is not reality, and he hasn't addressed reality when it comes to that alcohol consumption. So all in all, as I stated, I am in support of the recommendation. Thank you.
Thank you. All right. Kendall, I want to address you first. I want to say, well done. The difference between before and now after is amazing. I am so pleased at the progress that you have made. I'm so pleased at the adult responsibility that you've taken on. I'm impressed by the self-sufficiency that you're beginning to show. You've got your driver's license in a car, you're working, you're cooperating with DHHS and Wellspring. Your kids are well taken care of. Your house looks good. All of the things that we asked you to do, you have done, and you've done it in a way that says you're taking responsibility for it. You're not waiting for somebody to tell you, hey, you got to do something here. You're taking the bull by the horns and you're doing it yourself. So absolutely well done. I'm going to follow the recommendation in this case, ask that you do it for 60 more days. The only reason I'm doing that is to make sure that this is a habit and not just a big push by you and that you'll then go back to your old ways. So I fully anticipate at the end of 60 days, if you continue to do what you're doing, that we would release you from this court-ordered programs and you would be free to do what you need to do. Now, again, that assumes that you've got things in place with the custody and parenting time and friend of the court side of the case, but I'll get to your question in just a minute. But I want you to know that as long as you do what you need to do and what you're supposed to do, that's kind of where we're going. So I wanted to say, well done, good job. Did you have a question for me?
So FOC is not willing to put in a order for me. They said that I have to deal with my NA case before they will move forward. And I already have another date for FOC. That's why I was hoping to close out in like maybe 45 instead of 60. So that way I can go into like in the next week after that, because it's February 9th is my FOC with Kyle Legal.
Well, the 60 days will be up shortly after that. So I think you just do what you need to do with the friend of the court, let them know, and the order will say that we're going to review it for closure at the end of 60 days. So you'll be able to show that to the friend of the court if you need to. So you'll be able to deal with those things. So keep doing what you're doing there. I think you'll be fine. Any other questions that you have, Kendall? All right. Cody, I want to start out by saying you're doing better than I expected with your kids. The report indicates to me that you are doing well with your kids. You're anticipating their needs. You've got a good bond with them. You're on time. You're there when you need to be there. So I appreciate that. Here's where I'm not going to be quite so happy with you. That's the easy part because people are doing most of that stuff for you. Your parents are helping you with the supervision of the kids. People are setting up the visitation for you. They're telling you when to be there and what to do. When you're left to your own devices, I got absolutely zero from you. Through most of this hearing, I was trying to decide whether I needed to figuratively slap the crap out of you to get your attention, or whether I should be nice to you and say, hey, you need to pick up the slack. Some of your answers to me tell me that you absolutely do not get it. What you're telling me is drinking thinking. The fact that you think that cutting back to 4 beers from 12 a day is a good thing is ridiculous. Your kids were taken away from you. Whether Mr. Delaney wants to argue that or not, your kids were taken away from you in part because you couldn't function enough to clean up your house, and your kids were suffering from it. You've got a neurologist telling you that you might have alcohol-induced seizures and you're still drinking. You're talking about being a functional drunk when you're dealing with young children. Here's your wake-up call, Cody. Grow up. Stop drinking. You're putting alcohol in front of your kids, and I'm not going to have it. If you want to be a drunk, go be a drunk, but that means you're not going to be a dad. Do I make myself clear? Do you have a question? Go ahead.
I wasn't saying that as like what I am now doing. I'm just saying that in like aspect, if I would have done that and only dropped down to 4 beers, but I'm not drinking 4 beers a night. That's not what I'm saying. What I'm saying is, okay, yes, my case is my case, but I was just saying that as an example. Was what I was saying. So
the fact that you're still drinking at all.
Opinion, I understand that. I'm slowing down though, is what I was trying to say. I'm slowing down to the point where I'm not drinking every night. I'm not drinking like to an aspect where I'm passing out on the floor. Is what I am now saying. I'm not doing that anymore. I have grown up. I understand the last time we had this conversation, I've slowed down. I am trying to do all the stuff that is in my recommendations. Like I can stop drinking, but as I was saying, it puts me into the hospital because I'm, per se, okay, what I was drinking, and if I do stop, you're going through withdrawals. Withdrawals can kill you. So if you back off slowly, which I've done, I can say now I can stop drinking. But my examples were to say, okay, how can I drive and drink and I can't drink and take care of my kids? It was an example. I'm not saying that in any way saying that it's okay. Per se, I'm just saying as examples.
Cody, I run the sobriety court here in Otsego County, which means that I have 16 to 20 of the, I don't want to call them worst, but the worst drunks and worst drug users in Otsego County. I have heard every excuse that there ever was and ever will be. And I have to tell you that you're talking right now is closer to an excuse than it is anything else. So I'm not gonna harp on that point anymore. I'm just letting you know that kind of talk, that kind of thought isn't gonna help you in any way in this court. If you need to go talk to somebody about that and figure out why, then please do that. Talk to your attorney, talk to a counselor, talk to people at AA, but figure it out, son, because it is not going to help you in the future. The second point that I want to make is you are letting everybody else do the hard work. You haven't paid a dime yet towards any of your substance abuse. You haven't even gone to ask how much it costs. You gave a quote in your first statement that it would cost thousands of dollars that you would have to pay. That's ridiculous. It's a substance abuse assessment. You don't know how much it costs because you haven't done the work of finding out. You waited for everybody else to tell you whether or not they're going to pay for it. Now put your hand down. I'm not done talking. You haven't paid a dime in rent in a year and a half. You've been working full time for a year. Don't tell me you don't have any money. It's time to be an adult. We're going to review this matter in 60 days. If I don't see any results from you in 60 days, we're going to take a different tack. Talk to your attorney about what I mean by that. And it's not going to be fun for you. It's time to grow up and change your ways. Drinking is a thing of the past. Floating through life is a thing of the past. Figure out what you need to do and get it done, period. Don't wait for Wellspring or DHHS to do it for you. You've got a chance here to stay with your kids, and I think your kids would benefit from that. They would love to have their dad in their life. Don't screw this up because you can't figure out how to run your own life. All right, the order of the court is will remain under the care and supervision of DHHS and Wellspring. Will remain placed with his mother, Kendall. Will remain in the parental home with their mother, Kendall. Kendall should successfully complete the family reunification program, and she's doing well at that so far. Parenting time for Cody will remain supervised. Cody and Kendall will comply with and show benefit from their parent agency treatment plans, including all of the court-ordered requirements of those plans. The next hearing will be in 60 days to consider case closure as to Kendall only. That will continue as to Cody. Anything else as to this portion of the case, Mr. Sommerfeld?
No, just to discuss the status conference for.
That's where we're going next.
All right. Then
Mr. Delaney, as to this part of the case?
Nothing further. Thank you.
Mr. Brown?
Nothing further. Thank you.
Ms. Hansel?
No, sir.
All right. As to the Ireland matter, at the last pretrial, we set today as the pretrial for this case. There's been a request for a jury trial, although the department may be, depending on what happens in 60 days, is the department thinking about dismissing Kendall out of that part of the case?
Yes, that's a distinct possibility, Judge, based upon the report and where Miss Ireland is reported to be. The department would still proceed with Mr. Cody Ireland. I would anticipate a one-day trial, and that would be the request, and the standard, the jury instructions and witness and exhibit list, 14 days before trial, and then a week for the jury instructions and for us to come to a consensus. That would be me and Mr. Delaney and Miss Hansel.
All right. Mr. Delaney, your thoughts as to the trial coming up?
My client has requested that jury trial, and as the court is aware, the allegations are identical as they were in the case. So I would anticipate that Cody's view and request for a jury trial would continue and would remain the same. And then we can meet all the same requirements we had last time. And I was going to indicate that we would not I anticipate we'll have the same jury instructions, same verdict form. So I do not anticipate any issues with those documents.
All right, thank you. Mr. Brown, as to the
Your
pretrial
Honor,
conference?
I'm at a little loss here of how to proceed with the jury trial, given that this may not even need to happen. So I guess I would request that any trial be set out after the next review in the case, so we can see if it's even necessary.
And I think that's kind of where I'm going to go with this. Most likely is set the trial in early March or late February, probably early March, so that we have a chance to see how Kendall does for the next 60 days. But I'll definitely follow that request, Mr. Brown. Ms. Hansel, anything else from you as to the pretrial on?
No, I would support Mr. Summerfield on that, Your Honor.
All right, the court will set a one-day jury trial, likely in early March. The court will send out notices as to all the parties as to that. That will be in person here at the courthouse. The court will ask that the criminal jury instructions be agreed upon by counsel ahead of time. If there's any disagreement, we can review that at the final pretrial conference to be set 1 week in advance, approximately from the jury trial. Witness and exhibit list will be done 14 days in advance of the jury trial. Any evidentiary issues must be briefed and set for hearing at the last final pretrial conference. And then a pretrial conference will be set 1 week in advance of the jury trial, all per the court's standard orders. Anything else that we need to do today as to the pretrial conference?
Judge, I just would note that in Crawford County, March 11, 12, and 13, I'm set for a trial. There's another 3-day trial. It has not been set yet, but I'll keep the court apprised of that. But right now, the 11, 12, and 13 in March is, I already have obligations there.
All right. Thank you. We will try to make accommodations for that.
Thank you, Judge.
All right, that's all for today then. Thank you all very much.
Mr. Reynolds. And hi, Ms. Langley. Give you a chance to get settled.
Okay,
All right, hi, Ms. Langley. So we got Mr. Reynolds here. Are we ready to do a change of plea or?
yes, we are.
Okay, who's got the documents?
Your Honor, counsel sent me the document to me, but I haven't had a chance to respond to whether it looks like it might have the wrong charge on it. So
should we give you a chance to discuss while we do other things or set to tomorrow?
Yeah, let me take a look at it. I can't come back tomorrow. Let me take a look at it and I can probably figure it out.
All right.
Ms. Langley, please send that to the clerk and copy us. Thank you.
Okay, thanks.
With other cases at the corrections facility. Mr. Villarreal in Nisqually or in the corrections facility at county? Anybody know?
I think I saw on the Nisqually roster, Your Honor.
He's Nisqually. Okay, so we're done with the county and you can let them know that they can take Mr. Rosenberg and we can mute him and be done. Everybody else is at.
Ms. Langley, the form says trespass 1, it should be trespass 2.
Yeah, I realized that. I had started it that way and I thought I fixed it and I'll fix it again. It'll be on its way in a moment.
Your Honor, the city is in agreement with everything except I want the opportunity to double check. Ms. Langley indicated it was 20 days served. I just want a second to verify that. I know he had a DOC hold, but I don't think part of that time he was in custody for that reason, as opposed to this case where he'd been PR'd.
Okay, all right, well, we'll go through this plea and we'll take up sentencing later, but So, Mr. Reynolds, you're pleading guilty to this charge of criminal trespass in the second degree. And do you feel you had enough time to talk with Ms. Langley about entering this plea?
I believe so.
Okay, and in this plea are all of your rights to have a trial in this case. To understand those rights?
Yes, yes,
Do you know you're giving up your rights to have a trial in this case if you plead guilty?
yes, yes,
Is that your choice?
yes, yes.
Okay. I see there's a recommendation here. It's a thought that I should impose a 20-day sentence with credit against that, however much is determined, and then tell you to stay out of the Walmarts, all of the Walmarts in the city of Lacey, and stay out of trouble. And then over the next year or two, then if you follow the court's order to not violate the law and not go back to the Walmarts in Lacey, then there shouldn't be any reason to impose any more jail. Do you understand that?
I do. I do.
Now, do you know I don't have to go along with that recommendation?
I do. I do.
So I could impose anywhere up to the maximum. In this case, it's 90 days in jail and a $1,000 fine. And you're aware of that?
Correct. Correct.
Okay. Now I've asked you to make a written statement here as to what you've done wrong that makes you guilty. And you're saying, where's that? That on September 10th of 2025, you were hiding on the roof of Walmart on Yelm Highway, a place clearly not open to the public. You'd been asked to leave the premises earlier in the day. Do you accept that as what you did wrong?
I do. I do.
All right. Now, has anyone threatened you with harm or made you any promises that have caused you to plead guilty?
No, Your Honor. No, Your Honor.
Okay. Well, how do you plead to that criminal trespass in the second degree?
Guilty as charged.
Okay. I will accept your plea then, and I'm doing that finding you know what you're doing. You're doing this voluntarily and intelligently, and I find you're doing this understanding the consequences of pleading guilty, and your statement there supports all this. And then we'll move on to sentencing. So I'll hear from the lawyers, but I will turn back to you as well. So first off, ready to go, Ms. Eddy?
Yes, Your Honor, the agreement of the parties is that Mr. Reynolds will serve 20 days jail, that he'll be on probation for 2 years with the condition no law violations, stay away from Walmart, and legal financial obligations as determined by the court, by the cities. The statement of plea form indicates that it's credit for time served. Lacey's in disagreement with the defense that he served 20 days. By my calculation, so I believe he was arrested for the offense on September 10th. He was arraigned the next day on September 11th, where he was PR'd. So if you consider that to be 2 days jail, then I don't indicate he was in custody again until he refused to appear before this court on December 15th and has been in custody since then. So December 15th to the 23rd, an additional 8 days. So by my calculation, that would be 10.
I also see another time, and maybe Ms. Langley will clarify, September 29th that he was in custody. So Ms. Langley?
That's what I thought, and I found the docket confusing because I couldn't tell when it was coming and going, but I think he was in another time. I don't have jabs open right now, so we can clarify that, and then after that, I'll simply defer to the city.
Okay.
I think there was one other time picked up, and either release.
September 29th, we had a hearing when your client was in custody, and then he was released. I don't know if it came when he came in.
That was my.
I'll jump in to help
Sure.
out. Well, he wasn't subject to a hold in Lacey on the 29th. So that should count regardless. He was up for review for whether the court should impose a hold, but it didn't happen. Additionally, though, and in his favor here, it looks like that warrant was served December 13th. So you could add 2 days to that calculation. So it comes to 12.
Okay. All right. Well, Mr. Reynolds, anything to say about what I should do here at sentencing?
I was hoping to get the things ranked concurrently because by my calculations, I've sat in here because I've always come in on DOC warrants. The DOC time doesn't start until after you get these taken care of. So I've sat in here for at least over a month on this charge alone. So I was hoping to get it ran concurrently so I could get out for my birthday on the 3rd, but that's all I have to say for that.
Okay. All right. Well, and what are your plans here? I mean, you get out, you have a place to live, place to work, what?
I'm actually going to go into rehab when I get out.
Okay. Good. So you have some resources or somebody who's going to help support that?
Yeah, I'm going to ABHS.
Good. Okay. All right. Well, I hope that kind of solves the problem of you ending up here in court. You know, I'd rather you have a better life than this. Right. So, well, I think there's a 12-day sentence here. I'm going to, essentially, I think you'll be released very quickly if you get good time. I'm going to go along with this recommendation in 20 days. You've earned that. 12 days credit against that. 8 more days to serve. If you've earned good time, then the facility provides that. So you may very well be out sooner than 8 more days.
One other request, Your Honor, I think is what he was alluding to, is that he's been in custody. He was picked up on a DOC warrant for this originally. That's why they were arrested him. And then he's done more DOC time. What he's explained to me is that although he's held on DOC, they haven't yet imposed the sanction. We're wondering if the form could simply indicate that this could run concurrent to DOC time. I don't think it makes any difference here because he hasn't been sentenced on DOC. So it would just give them, he thinks, more flexibility in their sentencing. Doesn't change a thing for Lacey. So thank you.
And Your Honor, that was not the agreement of the parties that this would run consecutive to any other DOC sanction.
Or concurrently with?
I'm sorry, yeah, that it would run consecutive. It would run. So it was not negotiated by the parties. Additionally, the defendant, I believe, is on DOC custody for robbery, and I don't think he should be rewarded for being on top of Walmart while on DOC custody for committing this crime with having his sentence run concurrently.
Well, the 20 days is a fair sentence for what this is. I'm going to stick to that. 8 more days to serve unless you've earned good time. And it's up to DOC to make those decisions about are they going to run things concurrently or consecutively. I'm the first sentencing judge. I don't decide that. It's the second one.
No, I have already been sentenced by DOC, so if you are the second.
So what did they sentence you to?
To 13 days. So I'd be out on 26 by their sentencing, but that time doesn't start. So the 13 days doesn't start until this court date is over with.
All right. Well, like as I said, the 20 days is apt for this issue, whatever is going on elsewise. So are they going to be helping you get into ABHS as well?
Yes.
That's good. Okay. Well, and then as to the probation issues, no further sanction on those, just stay law abiding and stay out of the Max the Vape store, stay away from there. Those are the only conditions on those 2 cases. And but that's it for today. And then good luck at ABHS. I hope you have a much better 2026 after that.
So is there no concurrent ruling?
No, I'm not going to run it concurrently. This is an appropriate sentence for the theft itself. That's it for today, unless you have other questions.
I'm just wondering how the calculation is already past the time served for this, the amount of time I've done here for this.
Well, the time that you served on this case, the 12 days is what I've determined and with the help of the attorneys, that you should get that credit. And so those 12 days are throughout the history of this case, receive that. If there's something else, if we got something from Nisqually that told me that you served on this case more time, you certainly should get that. Let us know that. Get a kite over here with some confirmation from Nisqually jail that tells us that.
So the only thing is that I've been PR'd a few times, but I didn't get out because of the DOC holds, but not.
Yeah, and that means that you're not held on the Lacey case. You're held on the DOC case. And I can only give credit against something that you're held on this cause number. So I've been told 12 days. I'm going to go with 12 days. But if you think there's more held on this cause number alone, then I certainly would like to know about it with corroboration from Ms. Qualley. So I don't think there's anything more here, but I welcome if Ms. Qualley thinks there's more than 12 that you served on this cause number. I'm happy to change this order up, but gotta get that information to the court so I can do that. That's it for today.
Thank you.
Thanks.
I think that's it for me. So good day, everyone.
Thanks, Ms. Langley.
And Your Honor, if we could call Mr. Stacy, he's number 13.
Zachary Stacy.
Yes.
All right, I see you on Zoom. All right, good afternoon, sir.
Yes.
All right, is your full name Zachary Anthony Stacy?
Yes, sir.
All right, date of birth, January 28th, 1993.
Yes.
Good phone number, good mailing address for you still on 184th Street Avenue in Rochester?
Yes.
Yeah, Mr. Wright, were you able to get a good phone number?
No, Your Honor.
Mr. Stacy, is there a good phone number where you receive text messages?
360-559-3360.
That was 559.
Yeah, 360-559-3360.
All right. Okay, sir. So this is, we're here for an arraignment on a charge of assault in the 4th degree, non-domestic violence.
Yes.
That's a gross misdemeanor punishable by maximum penalties of 364 days of jail and a $5,000 fine. And did you have a chance to speak with an attorney today?
Ish.
Go ahead, Mr.
Your Honor, Mr. Stacy has been advised of his rights. He, excuse me, he's represented his household income is about $3,000 per month. He supports his spouse and a child. Asking the court to establish probable cause. If probable cause is established, asking for an attorney to be appointed and for not guilty plea to enter. And the reason we're asking to establish is there's a possibility that this could be a self-defense case.
Yes.
And I believe that the police report potentially supports that Mr. Stacy was not that there's not sufficient probable cause to show that Mr. Stacy committed an assault.
Okay. All right. So just before we get started on this, Mr. Stacy, I don't have a police report in front of me here. So what I'm going to do is the prosecutor is going to give some testimony about the allegations here. This is not your guilt or innocence. It's just to determine whether or not there's at least probable cause of the charge of assault. That's just if there's a reasonable basis for believing a crime may have been committed. That just lets the court set conditions while the case is pending. You're still presumed innocent and all of that. It's just a matter of did the state meet that initial burden to kick off the case and set conditions?
Yep.
All right. So that's what's happening next. Ms. Facio, you are already sworn in, so go ahead.
Just briefly before I begin, Your Honor, is this for, I have for 2 counts of assault for, is that, I'm unsure if the if the complaint was filed amended initially, or I just want to be clear before we go forward.
Looks like there was an amended complaint. Yeah, so that is in the file. So Mr. Stacy, there's actually, looks like there's 2 counts of assault, both non-domestic violence. One count with respect to a William Frank Bradford and another with a Rusty Allen Bradford.
Yeah, that was the exact same night.
And Mr. Stacy, it's really important you not say anything at this hearing, just because, again, you're on record and there's a prosecutor here. You have the right to remain silent. So if you, I'd recommend you speak with an attorney before addressing the court on the allegations here. All right, so yes, Ms. Facio, thank you for clarifying. There are 2 counts here.
On November 1st, 2025, Officer Stevenson was dispatched to a report of a fight located at 10333 184th Avenue Southwest in Thurston. It was later determined that it actually occurred at 10328 184th Avenue Southwest. The reporting party was a William Radford and was yelling at a subject named Zach, later identified as Zachary Stacy, the defendant in this case. When reporting, he told dispatch that Zach had assaulted him and his son, Rusty, who those are the 2 for the 2 counts. When reports, it is quite a long, just candidly, it was quite a long police report, but and looks like there is some back and forth, but when the officer spoke to William, it looked at their residence. William had a small cut on his nose and red marks on his eyebrow and a small cut on his chin. He reported that he went over to Zach's house and Zach told him to calm down. He got in William's face. There was a short argument, and then William started walking away to go back to his house. William reported to the officer that Zach came at him, grabbed the back of his jacket, and then when William turned around, Zach punched him in the face, causing a cut to his nose. William then said his son, Rusty, charged at Zach and tackled him to the ground, and that a fight ensued where everyone was punching each other. William went out to the front yard and driveway. He grabbed an axe to protect himself and Rusty from Zach. William then said he noticed Rusty had Zach restrained. So he dropped the axe as it was no longer needed. He went to the front door to get Zach's wife, Tina, to come outside and help control him. When they came back outside, Rusty had released Zach and they were walking away back to their house when they thought they heard the gun cocking and then ran back.
Can you go back to what forms the basis of the charge for Rusty?
I believe, candidly, it is quite a convoluted report, but I believe for the Rusty's aspect, that is, one moment, Your Honor, I'll find where I'm referencing in the report.
Do we have either of the Radfords present, either in court or on Zoom?
I believe the punches that were thrown in the scuffle, and there is a report that Zach potentially headbutted both William and Rusty in the incident.
So it sounds like there's reports of a scuffle. Is there anything in the police report? It sounds like it's long, specifically where it's alleged that Zach headbutted or made any other kind of contact with Rusty?
Zach had stated that, I believe part of it too, Your Honor, came from the report of the handgun being brought out and
self-defense.
Stacey, make sure not to say anything.
At both William and Rusty here.
Probably, but and yeah, just make
So
sure you exercise the right to remain silent. Sorry, go ahead, Ms. Wilson.
I believe that it came from the punches in the scuffle, the headbutting, and then the cocking of the handgun.
All right, well, here's what I'm going to do. William and Rusty lived together sounds like they're father and son, is that right?
They are father and son. I believe they live together.
And then what's Zach, Mr. Stacy, is he a neighbor? He doesn't live with them, is that right?
I believe they live together.
No.
Mr. Stacy, do you live with the Radfords?
No.
All right. It looked like I assumed that just because the civil standby checked is not needed. Okay, where do you live in proximity to the Radfords?
About a football field away, so to speak.
I missed that. Well,
as the crow flies, about a football field away, give or take. He's like a few driveways away. And when it
so okay, so you're a couple of houses down or a couple of residences down?
Yes.
You say you're within 1,000 feet?
Give or take, yeah.
All right, well, here's what we do. I'm going to find probable cause with respect to William, but not Rusty at this point. Mr. Stacy, again, it's probable cause is whether there's a reasonable basis for believing a crime may have been committed. Now, it may not have been, but there are allegations against you supporting that a crime may have been committed at this point.
Judge, can I speak for a second, please? So how can I?
You can, but you may incriminate yourself.
No, I'm not.
I advise that you not.
There's two men that went into my household, assaulted me, and now now I'm going to court over this.
Well, there's an argument that
inside my household in the state of Washington, that's self-defense.
So you've got an attorney who's going to be able to help you make that argument. All right,
No, it's a fact.
When there's probable cause for count 1, not count 2.
It doesn't make
sense. I see that there's a request for a pretrial no contact order as well. I'll allow argument on pretrial release conditions. I see that there's one in here, a proposed no contact order. I'll go ahead and discuss it.
So with regard to count 1, then the state would recommend PR with no new law violations, no firearms or deadly weapons, and then the no contact order for William.
I don't know that there's a mandatory restriction on firearms in this situation. I don't know that it's necessarily warranted in this situation either. With regard to any sort of no contact orders, I suggest that if the court is going to issue a no contact order, that it include or that it be limited to direct contact with the victim or the victim's property. I don't know what the layout of their sort of neighborhood or street is. If there's a distance prohibition, that could sort of cut Mr. Stacy's ability down significantly to access his own home or property. So since we're not really sure what the distance is, perhaps, and since this is not a domestic violence situation, if there is a protection order issued, we just ask that it include or be limited to William and William's property, and that there not be a firearms prohibition associated with that.
There was reference, Mestasio, to a firearm. I think you mentioned that. at some point. What was the basis for the firearm prohibition?
Just the reference in the report that the defendant here had, I guess, cocked a handgun or some sort of firearm at William and Rusty.
I don't know, there was a firearm found at the scene, Your Honor, but the allegation was a firearm involved.
No.
So it came after. Mr. Stacy, hold on a second. And any allegations of any firearms would come after one of the alleged victims theoretically grabbing an axe. So, I don't know that.
An axe.
Yeah, I want to make sure we're clear. So is reference to the axe a reference to a deadly weapon, or was there allegedly a gun involved? Mr. Stacy, I'm asking the lawyers.
Sorry.
Okay.
Your Honor, apparently Zach said William swung an axe at him. And I don't recall if that was mentioned from William's statement, but
Ms. Vassar did reference that gun being cocked.
In the police report, direct quote, Zach stated William and Rusty wouldn't leave, so he went inside, grabbed his handgun and cocked it, and then handed it over to Tina. That's
all right. Thank you. All right.
on there, that wouldn't be, that would just insinuate sort of the presence of a firearm, not necessarily the use of a firearm, especially if he cocked it and then handed it to someone else, if there wasn't any sort of brandishing or aiming or threatening or anything like that. I just don't see that as a necessary condition, Your Honor.
Well, so here's what I'm going to do. So Mr. Stacy, I'm not going to, so you'll be released on your own recognizance, so there's no need to post bail. I'm not going to impose any no contact orders in this case. The allegations are that the folks here came to your house, so I'm aware of that. And you don't live together. It sounds like any kind of no contact order that involves kind of trying to mess around with distance restrictions to accommodate where you live, where you may pass by their house. I don't think that's necessary here. I'm also looking at your history. I'm not seeing any history that would indicate to me that there's a need at this point for something like a no contact order. So there's not going to be a separate no contact order where if you were to violate it, there would be grounds for violation of release conditions as well as new criminal charges. I am going to put as a condition that you just have no contact with William Frank Radford.
100%.
So that's a pretrial release condition, right? So there's not a separate court order or anything like that that can be the basis of a new criminal charge. But a condition of pretrial release is just to have no contact with them. I am also going to require that a condition that you not possess any gun or deadly weapon. It sounds like part of the allegations here was a cocked handgun that was part of the scuffle. Okay. Again, sir, these are just allegations at this point. But considering that I think that at this time, there's enough there for not possessing a gun or a deadly weapon to be part of a pretrial release condition. So I'm going to include that as well. The only other condition is to not have any criminal law offenses while the case is pending. And we're going to set a pretrial hearing for January 21st at 10 a.m.
I just don't understand how someone can come to your house and you defend yourself.
Mr. Stacy, if you'll reach out to my office later this week or early next week, we'll get an attorney assigned to you that can discuss that with you.
Yes.
It's basically, the situation right now is largely precautionary based on the differences of information that are appearing in the police report. So that's why you need an attorney to kind of work through that with you and then work through that with the court.
Okay. Yes.
Yeah, and if I didn't say it out loud, I'm appointing Thurston County Public Defense to represent. Okay, Mr. Stacy, that's all for today. You've got the public defenders to represent you. Give their office a call the next couple of days. They'll let you know who their attorney is and you can start working on your case.
Yes, sir.
Thank you, sir.
Bye-bye. You stupid.
Anything that you say is gonna.
No, I didn't say.
Mr. Stacy, you didn't log off. Okay, Mr. White.
Your Honor, I guess if we could sort of call through the list of dismissals and see if anybody's here. That's all the people that I've met with so far. So I don't know if anybody's waiting. Mr. Lofgren, I believe we call him. Dismissals are showing up on Zoom that the state wants to call. We can do that.
Ms. Basio, do we have dismissals that we can run through?
Yeah, absolutely. I apologize if we've already dealt with a couple of these. Is number 2 and 3 on the 1:30 calendar? Is moody?
I'll step out and meet with people while the court's doing that.
This is Jason Higginbottom here.
Okay. Are you just letting me know you're here?
Yes.
All right. And so folks on Zoom, Preston White with the Public Defender's Office is here. If he hasn't met with you already or anyone else from the Public Defender's Office, they're going to start meeting with folks as they come. Yeah, Mr. Jackson.
I'm also here, Mr. Jackson. I've been here for the whole time.
All right. Thank you, sir. So, yeah, the attorneys are going to try to meet with folks as soon as they can, okay? And when they're ready, we'll call your cases.
Really need to meet with an attorney. I just want to get it going.
All right, Mr. White will be with you as soon as he can, okay?
Okay.
So that was John Bismuti.
Yeah, and with both of those, there's a tracking infraction, but the state doesn't take any stance on that.
Your Honor, would I be better to come to the court?
No, there's one public defender here. He's meeting with people as fast as he can.
I wasn't looking to meet with the public defender. I just want an opportunity to speak with you and get the case going. It's not that big of a case. It's called a hit and run, and the reality is,
So, Mr. Jackson, I'm going to advise you strongly to not say anything because while you may not think that's a big deal, that could still land you up to 90 days in jail with a $1,000 fine. So you can certainly proceed without an attorney, and we can go through that. There's a back and forth. I need to make sure you understand exactly what that means if you're waiving your right to an attorney. But it's a criminal charge, so it might not seem like a big deal, but it has some pretty serious consequences.
but it's not a hit and run.
Okay,
I
so
live across.
Mr. Jackson, please stop addressing the court. There's a prosecutor here. You're on the record. You may be incriminating yourself, even if you don't think you are. All right, that's why we I suggest you talk to the public defender first, right? And if you still feel like you want to move forward without representation, that's fine. But I want you to talk to Mr. White first, all right?
Okay.
All right. All right. Go ahead when you're ready, Mr. White.
Hey, Sean, if we go, Mr. Jackson.
All right, Mr. Jackson. All right. And your full name is Kevin James Jackson?
Correct.
All right, date of birth, November 7th, 1971?
Correct.
And a good mailing address for you, Hanson Street in Tumwater?
Correct.
All right. And go ahead, Mr. White. Well, I'll start here actually first. Sorry about that. Mr. Jackson, we're here for an arraignment on a charge of hit and run of an unattended vehicle. I know we kind of talked about this before, but that's a simple misdemeanor punishable by 90 days jail and a $1,000 fine.
No,
all right,
not happening.
Yep. Sorry, Your Honor. Mr. Jackson's been advised of his rights. Stipulated probable cause for the purpose of today's hearing, asking that Thurston County Public Defense be appointed. Mr. Jackson has represented that he receives benefits that would make him eligible for appointment. And asking that a not guilty plea be entered.
I also have something else to share because I printed out some of the Washington state laws, and it is illegal to park an uninsured car on city streets for over 6 months. And this car has not,
Mr. Jackson.
this
Mr.
car
Jackson,
hasn't moved in 8 months.
Mr. Jackson, all right, I understand. That's separate from this. And again, I want to advise you not to make any statements about what happened with that parked car because you may be incriminating yourself, all right? So what I'm going to do is enter a plea of not guilty to that charge, appoint the Thurston County Public Defenders to represent you, all right? Now I'm going to turn it over to the prosecutor for recommended conditions while the case is pending. Go ahead, Ms. Fazio.
Personal cognizance with the
I
standard.
just want you to know, as I shared with you previously, I have a lot of health issues and I don't have a lot of time to deal with a lot of the just crap. So if there's something we can just put on the table and say, hey, here's your ticket, here's your this, let's get over it. I'll pay
Mr.
for
Jackson,
it.
that's why you've gotten an attorney to help you work through this case, all right? It's not a ticket.
But I
and it's
don't need that.
All right. So conditions while the case is pending are not to commit a criminal offense and not to drive without a valid license and insurance. Next, we're going to set a pretrial hearing for January 21st at 10 o'clock. All right, you've got Thurston County Public Defense to represent you, so talk to your lawyer and they'll help you out, okay?
If that's what you actually feel is necessary for something so trivial as this, I would much rather just pay the man as I have offered to do so. And
okay. Well, again, it's not just a payment, sir. It's potential jail time of up to 3 months. So I've entered that plea of not guilty. You've got an attorney.
I'm definitely not going to jail because then you wouldn't be able to put me on my liver transplant list and all of the other things that I'm on. So that's...
Jackson, your hearing's over today. You're free to go, okay? We'll see you back here next month.
Yeah.
Okay, Mr. White.
Here comes Emma, present in court.
Probably not kicking it. Thanks.
Oh my. I mean, what else can I say, ladies and gentlemen? Kevin, the star of the show. I hope he gets some help. I hope he finds whatever there is at the end of that rainbow. But tonight, ladies and gentlemen, he is our little bit of Christmas Eve and a little bit of a present from me to you, a little cherry on top of the show, a little bit of weirdness to go along with the season. I hope everybody is having great plans, whether you're by yourself or with your family or anything else. It's the season to be happy and joyous and all of those good things, and thankful that we are not in these situations that these people have found themselves in. in tonight's program. I thank you again, ladies and gentlemen. Come hang out with us tomorrow. We're having a big old Christmas special. It starts at 7 p.m. Central Time. Oh, yeah, let me do this. It starts at 7 p.m. Central Time. And we're going to go until probably 10 o'clock or later. 3 hours is the plan. That's the high level plan right now, ladies and gentlemen. It's mostly done, actually. You're going to have a lot of Kansas. We're going to be spending some Christmas in Kansas, ladies and gentlemen. Some of that time is with Judge Ricky, too. I'm looking forward to it. I'm looking forward to seeing everybody who has the opportunity to be here with me and Mama and everybody else who's hanging out. Chat will be chatting and we'll be watching court just like always. 8 p.m. Eastern Time, 7 p.m. Central Time. Come on by. Nothing has changed for the rest of the week. Friday and Saturday are the same too, so make those plans as you have them available, but make sure you enjoy yourselves in this wonderful season of joy and thankfulness. Happy Christmas and Merry Hanukkah, and I hope you have a groovy New Year too if I don't talk to you before then. Ladies and gentlemen, I am your Lone Wolf Usul. I'm your curator for these here videos. I'm your host for this here channel, and I will see you next time. I am out. But before I hit this little stop streaming button, I want to say very special thank you and very Merry Christmas to Marty, Math Girl, Great Granny, and Zach. Thank you all. I really appreciate all of you. Every single one of you. Everybody in chat. You're all great. All the lurkers too. All the raiders, all the non-raiders. Everybody. You're great. Merry Christmas, everyone. Bye now.